The opposing attorney, his client, any other attorneys in the room, the opposing expert, and any techie on the other side of the table want to know how much you know. Some of them will have read your expert report, and so they will know roughly what you are about to say. They may not know all the details, since none of them will have seen your notes yet. Most of them will not have read the documents or materials that you used during your investigation and referenced in your report. But they do want to get a look at you. They want to measure you. How do you look? How do you sound? The lawyers will be assessing what effect you can possibly have on a jury if the case comes to trial. The client on the other side of the table wants to know if you are a better expert than their expert, if you know more than their expert, and if your assessments are correct or not. They want to know if you are better able to present the technical elements of the case than their expert. If they know that they are on the right side of the facts, they will want to know if you are simply a hired gun who will say the opposite of whatever their expert is going to say. Perhaps they just want to know whether you are an honest expert whose opinions will help reduce the extent of their success in the case. Then again, if they know that they are on the wrong side of the facts, they will want to know if you have the proof against them. They will want to assess if you have done a professional job in coming to your conclusions, and if you have the ability to sway the jury into accepting those results. In short, everybody wants to discover as much as possible about your background. Your knowledge and experience support your qualifications to do the job, legitimize the opinions you offer, and suggest how strong a witness you will be when presenting those opinions in a trial. An important tactic to realize here is that the strength or weakness of both sides of the case depends not only on the facts in the matter, but on each expert's ability to present analyses and opinions to the, quote, triers of fact, end quote. The phrase triers of fact refers to the people responsible for the final judgment of the case. This may be jurors, or it may be a judge alone in a trial that does not involve jurors. When a judge alone makes the sole determination after hearing the evidence, it is called a bench trial. The participants in the litigation may also have agreed on the use of an arbitrator or mediator who may have similar responsibilities to these more recognizable triers of fact. Just remember that the other side wants to discredit you. Keep in mind that this deposition process may be presented to you, often by the opposing counsel, as simply a discovery process. We're just trying to get the facts here, Mr. Robbins. I've heard that before. Attorneys have said that to me in deposition. We just want the facts, that's all. The statement is sometimes just an attempt to cause you to drop your guard and to be more relaxed than you should be. Yes, of course, they are trying to get the facts out, but that is not all they are trying to do. An unstated goal of the deposition day is to somehow get you to put statements on the record that may later be used to embarrass, discredit, or even disqualify you. A key goal of the opposing attorney, through the intensity and thoroughness of his questioning, is to uncover any outright mistakes, notable weaknesses, or notable oversights that you may have made during the process of your investigations. In addition, the opposing attorney may ask you questions from different angles at different times during the deposition day. He is hoping that you will give answers that may be different enough that he can claim later at trial that the two answers sound contradictory. Many lawyers will use the deposition room as a battleground. If possible, they would like to destroy you as an expert witness right then and there. The reality which they realize through experience is that most legal cases never get to trial. A deposition, then, is often the only opportunity you may have to testify in the vast majority of your litigation support jobs. The rules here are looser for the attorneys, and they can get away with more risky questioning of you than they would be able to in a trial. The deposing attorney is trying to establish weakness in your opinions or in the facts that you collected and drew on for those opinions. He will either have an easier time at trial or a stronger argument for a better settlement with the other side. You must stay focused and stay alert in a deposition. Most of the time, your deposition testimony will be the only testimony you give in the case, and its strength and your preparedness can dramatically affect the results.